Bangladesh law.
Thank you, Anindita. Good morning to everyone. Assalamu alaikum. Today we are going to talk about the laws in Bangladesh in relation to mediation. I have a slide program, so if I can I share my slides?
Yes, sir.
Yes, sir, of course.
I need to be host disabled participant, so I need to be made a co-host, please.
Yes, sir. You already admitted, sir. Your slide.
Yes, I'm admitted, but if you don't make me a co-host, I can't share my screen. So host BIMS has to make me a co-host. Or you have to enable participant to share, then I can share. Good, thank you. Okay, so let's share my screen. Except it is, okay. Not a minute. Can you see the screen?
Yes, sir.
Okay, that was the coffee break we had yesterday. Now, let us talk about the training. First of all, I must say that I'm grateful to BIMS for creating this opportunity to train our judges into making mediation a process which can be used and which can be beneficial to our litigants. Not forgetting that we have a huge backlog of cases and that can be reduced, and also the number of cases coming in to inflate the backlog can also be reduced. Thanks to the judges who are participating today. Of course, this is a new path. This is something new. From information that I received yesterday, we cannot find any district where the district judge has in fact activated a panel according to the need of section 89A subsection 10. I could not find, I may be wrong. There may be information and I may not be looking at the right place. But the information is that there is no information about any mediation having taken place through this section 89A and 89A10. Yes, some mediation has taken place by the judges themselves. That is also part of 89A. And mediation is definitely taking place under the Legal Aid Act. Good news. Good news is always welcome. We have very good news. The Honorable Prime Minister of Bangladesh yesterday announced that we are no longer LDC. We are being promoted to a higher rank within the world community. We have achieved many things. We want to achieve more in the form of our mediation process. The Judicial Reforms Committee decided that we must tell the judges that this law provides for mandatory mediation. We must tell the judges what to do and how to go about sending a case on mediation. The Honorable Chief Justice has agreed to issue a circular. The circular is right now in the process of being drafted. Hopefully within the next week, it will be sent out to all the districts all the judges who are involved with the law to explain to them that there is mediation compulsion under the law. Now, what do you say to the parties when you send the case for mediation? What has been done so far is go and try to sort it out. Come back when you fail. I have to say that this is the wrong attitude that has been given out. It is a wrong message that has been sent to the parties who are sent on mediation under the provision of law. What the judges must do when sending a case to mediation, and you all recall that mediation, the step has to be taken on the filing of the written statement by the defendant. Simply telling people to go and do mediation and come back if you don't succeed is not good enough. And it does not bring good results. What we must have is a proper information pack given to the participants, particularly in the presence of the lawyers. The parties must be told that mediation is confidential. We've heard all about it yesterday. Anything you say during your mediation or discuss, or any documents that you show, even any admission that you make, will not form evidence in any future court hearing. So it is all confidential. Whatever you say in confidence to the judge, even to the other party, that will not be brought back to the courtroom should the mediation fail. You have to tell the parties that it is an informal procedure. Unlike in a court, the parties will be able to talk. In arbitration proceedings also, the parties do not talk. Arbitration is just a less formal form of court cases hearings. Here, the parties do all the talking. The mediator only influences the parties, encourages the parties to talk among themselves, to iron out their disputes, to work out their solutions. As we heard yesterday, the mediator is not a judge. He's not mediating. He's not judging the issues. He's not going to determine the issues. He's not going to even help the parties to tell them what the law either helps them or doesn't help them. He's simply going to tell them that you talk. You decide what is good for you. You decide how much you can give. You decide how much you cannot give. But at the end of the day, the beauty of mediation is that the parties themselves decide what the solution will be. And then when they decide finally that this is the solution, you give and take. You cut your losses. And when you reach an agreement, then you are good friends for rest of the time. You're no longer in acrimony. In a litigation, even in arbitration, one party loses, one party gains. The party who loses cries. The party who wins laughs. But there is more, because the party who loses then takes it further to appeal to the High Court, to the Appellate Division. So there is no end to the matter. Only last week, we had an arbitration case and we decided after 20 years, 17 years, I think it was, after 17 years, we decided that the arbitration proceeding itself was not properly done because the one party did not receive notice of the arbitration proceedings. So after 17 years of going through the process, the end result is that we have said you can go and have the arbitration again if you want. So the parties must be told what to expect, what to do, how to deal with the mediation. The parties are in control. They must be told that. You are in control. And importantly, you don't have to go through with the mediation. But if you do, then these are the benefits that you will get. Number one, speedy. The process is time-bound. You get your decree within 60 days. or in addition 30 days if the court allows it, or so 90 days in total. That will be the beginning to the end of the mediation. Mediation takes only 2 or 3 days, but the process may take longer. Sometimes mediation is completed within 1 day. And after the mediation is completed, the court is bound to pass a decree or order within 7 days from there. So you have a maximum period of 60 plus 30 plus 7. That's 97 days within which you can or you must have a solution. Either it will come to an agreement in which there will be a decree after the 97 days period, or before the 97 days period. If there is no decree, if there is no agreement, then you go back to court. And as if nothing has happened. Next, it is less expensive. Obviously, it is less expensive because the time you spend is far less than the time you would otherwise spend either in litigation or in arbitration. I gave the example. Arbitration took 17 years in the process, and at the end, no arbitration, go back to the drawing board, back to the square one. So, less expensive. And you can get legal aid for the mediation process. Legal aid to pay the mediator. That's as provided by the Legal Aid Act. If the mediation is undertaken by the court itself or the legal aid officer, then there is no cost to the party. And if the parties reach an agreement, there will be a decree, as I said, within 7 days after the agreement, and there is no right of appeal. So that will be the end of the matter. And obviously, you don't need to appeal because you have both agreed and you sign an agreement. But the mediator will be a witness. Your lawyer, if he is present, will be a witness. There's no question of any appeal. And most importantly, the agreement, if reached, will mean that you will have your refund of the court fees that you have paid for the suit. So, at the end of the day, as everybody says, it is a win-win situation. And most importantly, again, not by the law, but by the process, the end result is that you achieve peace between the parties. Mediator's job is to listen. I have put on the left-hand side, red. That is the litigant who is bringing the case. He's always very angry. He's frustrated. He wants his pound of flesh. The other side, well, yes, they also speak to the mediator. But the mediator speaks only when it is necessary to get the parties to talk. He maintains neutrality and ensures confidentiality. Mediation comes from 4 sources. There may be more, but I've listed 4 here, 4 important ones here. One is the auto-referral. If it is the term of the contract that there will be mediation, then there will be mediation. No court will take cognizance of any case if there is a term of the contract which says mediation, and unless and until mediation has taken place. Mediation by the legal aid officer. This is a specific law giving authority to the legal aid officer to give advice at the very first instance, should a party choose to go to him. So he has to look through the documentation, the papers of any party, and he has to decide whether there is a case to answer. If he decides that there is a case to answer, then he will advise the parties to go for mediation, to mediate, that he will himself mediate. And then last is the court-ordered mediation, which is a mandate of the law, as I will show you in our section 89A, and also court-ordered mediation, which is discretionary under other laws, including suits filed before 2012 and suits filed on the Oturin Adalat Ain, which are for the execution of decree. Mediation is also mandatory at the time of appeal. So not just the trial court, but the appellate court has also to go through the process of telling people about mediation and sending people to mediation. And that is under section 89C. 89D, as I said, mediation, you see, the history behind it is that section 89 was introduced, 89A was introduced in 2003, if I'm not mistaken. And at that time, it was discretionary. In 2012, it was made mandatory by amendment of section 89A. Now, this is where our law is different from other laws across the globe. We heard from our Indian friends yesterday that mediation is a discretion. So the court will decide that it is a fit case for mediation, and then they will send it to mediation. Whereas our law specifically says, on filing of written statement, send it to mediation. If it succeeds, well and good. If it doesn't succeed, yes, it will come back. The Orthorin Adalat Ain, again, it is mandatory after filing of written statement. The Arbitration Act, also, arbitration itself is an alternative dispute resolution. It is said to be better than litigation because it saves time and because it saves expense. That you will be surprised. Unfortunately, arbitration does not save time in all cases. Very often, it loses a lot of time, and at the end result is minus, less than zero. Because, as I said, the case last week that we decided, after 17 years, it turns out that the process of starting the arbitration was wrong. There was a fundamental error in as much as the party to the arbitration was not given formal notice of the proceedings of the arbitration. That is a mandate of the law. If that is not satisfied, then no arbitration. You go back again. So after 17 years, parties have lost their money, lost the money that they paid for the arbitration, and lost all the time, and not forgetting the hassle of going through the process all over again. So, as I said before, arbitration itself, the arbitration law itself, gives the opportunity to go for mediation even within the arbitration when the arbitration has started. So that, in my mind, tells us that mediation is a better process, better than arbitration. Because why, for what other reason would you say that even during arbitration you can go and mediate? It's a better option, that is why. Right. The Labor Act has also process of mediation, conciliation, etc. That has been there for many years. And I don't think I need to go into that at this stage. Any other law where the Code of Civil Procedure is applicable, again, I would say that because of Section 89A, any law which makes the Civil Procedure Code applicable automatically makes the mediation process applicable. So, for example, the Small Causes Act, Section 17(1), but not forgetting that the pre-trial proceeding under the Family Courts Ordinance about compromise and reconciliation by the court, that is a arbitration, but I think it cannot be said to be mediation, because do it how you like. The judges will certainly utilize the form of ADR and decide the issues between the parties, and they will amicably settle, hopefully. If they do, then that is the end of the matter. But our law itself is not a mediation process. It's an arbitration process or reconciliation process. Mediation by legal aid officer. Now, this is very important. We have some assistant judges amongst us today in the training. Any of them can be called up to be the legal aid officer. And according to the Legal Aid Act, কোড অফ সিভিল প্রসিজার এবং প্রচলিত অন্যান্য আইনের বিধান অনুসারে মধ্যস্থতা বা সালিশের মাধ্যমে কোনো মামলা নিষ্পত্তির উদ্দেশ্যে নিযুক্ত মধ্যস্থতাকারী বা সালিশকারীকে সম্মানী প্রদান করার একটা বিধান আছে এখানে। So the legal aid officer can pay, as I said earlier, can pay the mediator. And also the the advocate who is taking part in the mediation. উপধারা ও হইতে ই রসই এর উদ্দেশ্য পূরণকল্পে প্রবিধান দ্বারা নির্ধারিত হারে আইনজীবীকে সম্মানী প্রদান। 21 ক লিগ্যাল এইড অফিসার আইনগত সহায়তা প্রার্থীকে আইনে পরামর্শ প্রদান করিতে পারিবে এবং প্রচলিত আইনের অধীন কোন আদালত বা ট্রাইব্যুনাল কর্তৃক উহার স্থানীয় অধিক্ষেত্রের আওতাধীন এলাকায় কর্মরত লিগ্যাল এইড অফিসারের নিকট বিকল্প পদ্ধতিতে বিরোধ নিষ্পত্তির জন্য কোন বিষয় প্রেরণ করা হইলে উহা নিষ্পত্তির ক্ষমতা সংশ্লিষ্ট লিগ্যাল এইড অফিসারের থাকিবে। So legal aid officer has two roles. One, to mediate the case himself which has come to him. The parties have come to him for advice. Any party has come to him for advice. The procedure is laid down in the law. He will have to send notice to the defendant. And if the defendant appears, then he will ask both parties that if they agree to mediate. If they mediate, that's the end of the matter. Agreement reached, they will sign, he will witness, and it will go for court. And the second duty is if the court sends any case to the legal aid officer for mediation, then he will deal with that case as a mediator. Now, one question arises whether, because he is an assistant judge, he can deal with a case which involves an amount of money which is beyond his pecuniary jurisdiction as an assistant judge. The answer is very simple. The legal aid officer is not a judge. Here he is acting as a mediator. So there is no question of any pecuniary limit, since he is not judging the issues of the quantum of claim. Also provide provisions there, 3, 4, core. If there's a case to answer, then he will advise mediation. If the defendant agrees to mediate, legal aid officer will take steps. He will preside the mediation referred by the court under 21 core, rule 17, and notify the court or tribunal within 5 days if the agreement or there is a failure. Who can be mediators? Section 89A(1). The judge himself can be mediator, or he can send the case for mediation to the legal aid officer, who will deal with the matter under section 21 core 2. And this was added, this provision, this power was given in 2017. The other persons that can be mediators are the court-appointed mediator from the panel prepared by the district judge. As I say, I'm not aware of any district judges who have created any panels. On the other hand, I have been told that the president of the bar, who is to cooperate in appointing this panel, are very often not cooperating with the judges. So here I think we will have to take steps to ensure that the district bar presidents cooperate with the district judge in implementing the requirements of section 89A(10), subsection 10. Other mediator appointed by the pleader, if the parties mutually agree to another pleader or retired judge or mediator from the panel. So essentially what has to be said and seen is that it is the party who is deciding on who will mediate. পার্টিরা নিজেরাই ডিসাইড করবে যে এই কোর্টে আমরা করব মিডিয়েশন এই জাজ দ্বারা অথবা লিগ্যাল এইড অফিসার দ্বারা অথবা প্যানেলের কোনো মিডিয়েটর দ্বারা। The party will decide. They can appoint more than one mediator if they so wish. The only person, there is a bar on people holding the office of profit in the service of the Republic. Subsection 10, panel in consultation with the president of the district bar. So here we have to have the cooperation of the president of the district bar. And who can be kept in the list or the panel? Pleaders, retired judges, persons trained in dispute resolution, any other person who is deemed to be appropriate. The law does not specify how many persons are to be kept in the panel. But I would certainly say that as a rule of thumb, figure of 10 or 12, because you never know who will be available at a relevant time. So always better to have more on the panel than absolutely necessary, because then you'll have at least a choice. The duty of the judge. I have already covered this. I will just repeat it. The judge must explain that there is no compulsion to conclude the mediation. Here there is a difference. Mediation in our country is not voluntary. You cannot volunteer to go to mediation or not to go to mediation. You have to go to mediation. That is a fact. That is the law. But there is no compulsion to conclude. In other words, you don't have to go through the process and come to a final conclusion in the mediation. You are free to leave and say, no more, I don't want to have anything to do with the mediation, and that it will go back to the court. The parties choose the mediator. If the parties choose either the court mediation, the court itself, or the legal aid officer, then there will be no cost, as per law. And the cost of the mediation can come from the legal aid fund. And the other things that are there, I have already discussed earlier. The fees for the mediator, again, it is the parties or their lawyers who will fix the fees in consultation with the mediator himself. If they cannot agree on the fees, then they will go back to the court and the court will fix the fees. Under section 89A, subsection 3. If the court takes up the mediation itself and fails to mediate, and the matter goes back to court for hearing, and then it has to be dealt with by another competent judge. That is under section 89A, subsection 9. And that is very easy and clear to understand, because the mediation is supposed to be confidential. Whatever happens in the mediation does not go back to the court. And therefore, obviously, the judge who dealt with the mediation, who is now aware of all the facts, aware of what the parties have said, cannot continue as the judge to hear the matter itself, the suit itself. The appointment of mediator must take place within 10 days from the referral. So the judge says, go, mediation, choose your mediator. That must be done within 10 days. The choice of mediator must be completed within 10 days from the reference. If it does not happen, then the matter will go back to the court, and the court will then choose a mediator from the panel within 7 days thereafter. The result of mediation to conclude within 60 days from the date of the appointment of the mediator, and 30 further days on a joint application or suo motu consideration by the court itself. The result of the mediation is to be reported to the court. If there's an agreement, then the terms of the compromise in the form of a written agreement with signatures or left thumb impressions of the parties and signatures of the pleaders and mediators as witness. And within 7 days, the court shall pass an order to record the agreement, compromise, or satisfaction of the plaintiff and pass decree under Order 23, Rule 3 of the Code of Civil Procedure. And refund of court fees, I have already spoken about. There is no appeal or revision against the order of or decree of the court after the agreement has been reached in the mediation, and that is provided by Section 89A12. This is the attraction of mediation. It is an agreed settlement. So if it is an agreed settlement, then there is no question of going to appeal about it. Mediation, again, the law itself provides, shall mean a flexible, informal, non-binding, confidential, non-adversarial, and consensual dispute resolution process. This is all specified in the law itself. The mediator shall facilitate compromise without directing or dictating the terms of such compromise. So as I said, the mediator is the listener. He encourages people to talk amongst themselves. He encourages people to discuss their issues. Where have they failed? As one of our presenters yesterday said, go back to the stage, remind them to go back to the stage where things started to go wrong. Because by definition, when two people come to an agreement or join in business or enter a contract, things are good. They are happy. They are starting on a venture together, be it marriage, be it a social contract, be it any other commercial contract. So when the contract is signed at the initial stage, both parties are happy, they agree, they want to go ahead with this venture. But then at some point in time, things may and very often do go wrong. So that is where you have to go back to in the mediation process. Go back to the point where things started to go wrong. See why they went wrong. See who was at fault, if you like, but then not to pick the fault, but to amend the fault. Now, I have to tell you that non-binding, in the law itself, it says non-binding anytime. At the appeal stage, 89C, again, mandatory if it is an appeal from the original decree under Order 41 of the CPC. Again, same process. The court can itself mediate, or it can refer it. The Arbitration Act, Section 22(2). If settled by mediation, the parties apply to the arbitral tribunal to record settlement in the form of arbitral award on agreed terms, recorded under Section 38. The award is binding, but as an arbitration award, there is the possibility that it may be challenged on any legal issue. Although the agreement is mutual, but the award itself may be challenged. For example, we had a case of challenge in an arbitration case where the Contract Act was not considered by the arbitrator. But in a mediation matter, I think, again, since both parties agree to the terms and conditions, then there will not be any reason to challenge the award. So under the Ordinary Adalat Ain, Section 22(1), mediation, referral to mediation is mandatory after filing of written statement. Section 22(2), mediator by mutual agreement can be an independent pleader. Obviously not the pleader who has been chosen by the party as their lawyer to represent them, but some independent pleader and different pleader. A retired judge or a retired official of a bank or financial institution or other suitable person other than a paid government servant. The fees of the mediator is to be fixed by the parties, and when the agreement is reached, the terms and conditions are written down, and the parties will sign or put their thumb impression, and the mediator will be the witness, and the lawyers will be the witness. Under Section 22(6), inform the court within 10 days of the appointment of the mediator. If that is not done, then the court will appoint the mediator. Again, here is a time-bound process. Section 22(5), the mediation must take place within 60 days plus 30 days. 30 days extension if on application by the parties. Section 22(7), decree or order in terms of the written agreement. And again, the incentive to come to a decision. This is again, the court must tell the parties that if you successfully mediate your dispute, then the court fees that you have paid will be refunded. Under Section 17, the suit must be disposed of. This is the authoritative suit. Must be disposed of within 90 days plus 30 days from written statement, including the time taken for mediation. And disposal is final. There is no appeal or revision. So the mediator's job is to listen. By the time you come to the end, he has listened patiently, and you see, there is no more red words. There is no more animosity. Both parties have agreed. And therefore, even though they may have lost something, or even though they may have gained less than they had expected, still the parties go out happy. The tone of voice changes. There's no anger. Because through the process of mediation, you have decided that you will both agree to cut your losses and come to an agreement which will be better for you. Last time, if I remember, I gave an example of a case where in court it was a case under Section 138 of the Negotiable Instruments Act. One party had filed the case against his business associate, if you like, or business, the other side of the agreement. It was a business transaction between the two. One was a doctor, a qualified medical doctor. The other was an engineer. And they had had financial issues over the years, and they had sorted it all out. But then at one point, one party owed the other party some 35 lakhs taka. And a check was issued which bounced. So the doctor immediately put in a case following all the procedures under the Negotiable Instruments Act. And his contract, the other party was put into jail for a few days. But when the matter came before the appellate division, we called to both the parties to our court. And surprisingly, the doctor said in open court, although he was entitled under the law to receive the whole of the amount of the check, he said, if he pays me 10 lakhs, he had already paid half of the 35 before. And he said, if he pays me 10 lakhs more, then I will not ask for anything more. And then on a subsequent date, he said, I don't need anything more from him because we are still in business. He's in his business, I'm in my business, and we can still continue our business transactions. And that is more important than a few lakh of takas. So he forwent the remainder of his money which was due to him, although by law it was enforceable and he would have been bound to have been paid. So here, the party decided that, yes, a few lakhs gone, which I was entitled to, but this was business profit. So it meant less profit that he received from his from this client. But then, because of the prospect of future agreements, because of the prospect of future business, he thought, well, I've lost 5 lakhs maybe, but I will get 10 lakhs from him in the next venture that we enter, the next contract that we go into. So he was willing to cut his losses. And as a result, the animosity is gone. They are friends. They are in business, and they will make profit and loss and continue to do so. So I have finished well before my time. I thank you all for your kind attention. I wish the judges who are being trainers today all the very best of luck. And I hope that we can take mediation further in our country in order to, first of all, to create more peace, particularly in the commercial community. And more importantly, we want, from my point of view, we want less cases in the courts, because the courts are not a good place for anyone. And particularly when we have 4 million case backlog, we want less number of cases coming to the courts. Thank you all very much.
Thank you, sir.
Time for answering questions, so please go ahead and ask questions.
Thank you, sir, for your resourceful, enlightening, and fabulous presentation. Now it is the time for Q&A session. Ladies and gentlemen, if you have any doubt or query regarding any matter, you can ask it to our Honorable Justice Imanali, sir. Yes, MD Nazmul Hussain.
কে প্রশ্ন করছিলেন শোনা যায় নাই?
Yes, Mazharul Islam. Yes.
Sir, I might be wrong in understanding the section 89E, sir. Section 89E of Civil Procedure Amendment Act 2012, sir, where it is stated that government is to issue the public the official gazette for the commencement and application of section 89A and 89C, sir. So, do please explain section 89E, sir.
Oh, I can tell you the gazette has already been issued, and if I don't have the gazette right here, I had it. The gazette has already been issued, and the law came into effect in July of that year. So there's no doubt about that. You need not worry about the law not having come into force. The law has come into force, and the gazette has already been issued at that time.
Thank you very much, sir.
Yes, Mr. MD Nazmul Hussain, you can ask your question.
Assalamu alaikum and good morning. I'm highly privileged and honored to be a part of this training session, and I really owe Mas Beams for arranging such a beautiful platform through which we can gather a lot of knowledge, particularly on mediation, which is very necessary for this time. Thank you, His Lordship Justice Imanali sir, for his deliberation and for his enlightening speech. Mediation is really very much important to reduce the backlog of our cases. But for this, I believe I have been in judicial service for 11 years. But there is a circular issued by Honorable High Court in 2003 when 89A, Section 89A was incorporated in the amendment of criminal civil procedure, where in the circular it was said for the successful completion of a mediation, one judge will get 2 points, that means equal to disposal of the 2 contesting civil suits. And for the failure or the arrangement of the mediation process, judge will get 1 point. But so far I'm concerned, our authorities, especially our DSRs, Honorable District Judge Sirs, overlook this matter. We are all at the end of the month when monthly statement meeting is held. We are maximum time we are asked how many contesting cases have you disposed of. Nobody asks how many mediation process or how many mediation have you tried or arranges. Moreover, encouragement or promotional activities is must and very necessary, because Sir has correctly said there is no active panel of mediator in every district of our country. Moreover, the advocates are more reluctant. So promotional activities like using the platforms of social media or television or radio, such promotional activities is very much necessary. So humble request to the Honorable Judge, Mr. Ayman Ali sir, whether there is any attempt from the High Court Division or the government to promote the mediation process. Thank you, sir.
Thank you. Yes, I totally agree with you with regard to the promotional activities, because I think that is essentially absolutely necessary for the process to actually be fruitful. How we will do it is something that we have to think about. You have suggested about media. I agree with you again. Media can play a very crucial part in encouraging people to go for mediation. I've seen very many advertisements on the television. Not that I don't get very much time to look at the television, but sometimes when I do, I find that people are talking about various ways of dealing with cases, about legal aid. There's promotional ads regarding legal aid and so on. So I think, yes, you're absolutely right. And I agree that we must have promotional activities, promotional media coverage to encourage mediation. With regard to the points for disposing cases, I believe the circular issued in 2003, as you have said, is very important because mediation not only disposes of the case at the trial stage, it also disposes of an appeal at the appellate stage and a revision at the further stage and even the appellate division. So mediation, if you like, I would agree that it should get more points than 2. But certainly it must get 2 points as was declared in the circular. If you could give me the date of the circular, that would be helpful. I will dig it out and we will make sure that this is put into effect. Thank you.
Thank you, sir. I will try my best to give you the date of the circular, and I think it will come to our use and it will benefit us very much. Thank you, sir.
Thank you, sir, for your answer, and all the participants. Thank you for asking questions to Honorable Simonali, sir. This time, I am requesting all the participants to come on camera and mute the microphone. Right at this moment, I am humbly requesting Honorable Justice Geeta Mittal, ma'am, former Chief Justice of High Court.
After 5 minutes.
5 minutes more. So there's a chance for anybody else to ask more questions if you like. Well, if I can just make one point that somebody raised last time, that the law requires for the judge to report in a particular form, and that requires details to be written down. And my answer at that time was very simple, that you're not required to write down the details of what took place in the mediation. In fact, you are barred from writing down the details that took place in the mediation, because then you will be breaching the confidentiality rule. So all you are required to write down for the reasons for failure of the mediation is that simple: parties did not agree, or they did not like the mediator. That could be a reason. And that would be sufficient reason to go back to the court and for the court to consider whether he will appoint a different mediator and send it back again for mediation. So you do not write the reasons, detailed reasons of why the mediation failed, going into the details of the case itself, because that you are bound not to do. The law prevents that. But you can certainly say the mediation failed because the parties did not agree, number one. Or if it is relevant, then you can say the parties did not agree to this mediator, or the parties could not attend because of COVID and the time has passed. So these are the reasons that can be legitimately written down, but certainly the details about the case cannot be written down in the reasons for the failure of the mediation. Any other questions? We have still 5 minutes if you like.
Justice Imam, can I ask you a question?
Yes, Jamila, good morning, good evening.
It's morning. Almost 2 a.m.
2 a.m. Wow. Thank you for joining us.
I want to congratulate BIMS. And my question is, you mentioned the time limit of 6 days to refer to mediation, and there's also an extension of 30 days. Have there been any cases where that 6th day or the extension cannot be complied with? And is there any penalty or sanction if it's not complied with?
Very simply, the answer is that we do not have statistics at this point as to how many cases have actually gone through the whole process of mediation, which has lasted more than 60 days. Or if at all, in any case, there was any necessity to extend the period of 60 days. We don't have any such information. And so far as sanction is concerned, there is no sanction in the law. The parties, after the 60 days or just before the 60 days, if they then think that the mediation cannot be concluded, the parties will jointly make an application to the court, or the court can, of its own motion, grant the 30 days that the law allows. And again, there is no sanction. If the mediation cannot be concluded within the 60 plus 30 days, then automatically it goes back to the court.
Thank you very much.
Any other questions?
You still have 3 minutes. If you have any question, you can ask to our Justice Imanali, sir.
Sir, namaskar, sir.
Bolen, ji, namaskar.
Sir, I have heard your lecture with rapt attention, and I have been really enlightened by your this great speech. Sir, I would like to make a question about this, sir. Sir, we find that in our court, I always try to make a mediation between the parties, but unfortunately, I find that the advocate seems to be very much reluctant and unwilling to proceed on this issue. And I observe that they have a vested interest not to make this approach successful. So I would like to know, sir, from your lordship, that how we can overcome this reluctance, sir. Thank you, sir.
Well, on this point, we had a very good suggestion from Justice Joseph yesterday. And he said that if you tell the lawyers that you must do it, they will say, make me do it. You can't force me. They will tell their clients, don't do it because there's no binding on going through with the mediation. Yes, we can go to the mediation. Tomorrow we'll come back and say, we don't like mediation. But what Justice Joseph said was engage the lawyers. Put them in the driving seat. Tell them, I need your help in this case. These are the issues. I need your help to talk to your clients. And I need your help to get your clients to talk to each other. Please cooperate and help us to help your clients to come to a decision, better decision by mediation. So you are then throwing the ball into the court of the lawyer, and the lawyer is obliged to help the court. So that way, hopefully, you can say to the lawyer, please help. Now, as Mr. Goswami said yesterday, I did that. I do that quite often in the appellate division. I tell the lawyers, well, this is a good case where the parties must sit together. So they come back and tell us that the parties did not agree. So I tell the lawyers, what did you do? You did not play your part properly. So I tell them that, look, you are an officer of the court, and we are seeking your help. So you must tell your clients, explain to your clients our views. I've done that many occasions. I've sent the case back and forth 2 or 3 times, telling each time to the lawyer, I want you, the lawyers, first of all, to talk between yourselves. In other words, between the 2 lawyers, and iron out the issues. And then you explain to your clients what the issues really are, and where you can draw the line, and where you can come to a conclusion, agreement, which is maybe a bit of give and bit of take. And on the second or third occasion, they agree. There is one particular lawyer who will not even advise his client. And we have told him,
Thank you, sir.
Mr. Lawyer, you have done your client a disservice because he stands to lose as a result of your inactivity. So get the lawyer on board. Don't antagonize the lawyers. Get the lawyers to help you, knowing that they're helping a judge of the court that they're going to appear in tomorrow and the day after and the day after that. They will help you, I believe.
Thank you, sir. Thank you for your answer and time consciousness. Honorable Justice Ms. Geeta Mittal has already joined us. Right at this moment, I am humbly requesting Honorable Justice Geeta Mittal ma'am, former Chief Justice of High Court of Jammu and Kashmir, to describe the role of judges in promoting mediation. Geeta Mittal ma'am.
Salam Anandita, Justice Iman Ali, all the learned judges who have joined this meeting, and I understand there are some lawyers as well. Very good morning to all of you. I thank the Mediation Society for giving me this opportunity of joining this meeting with you and sharing whatever little experience that I have had in mediation, which to my mind is integral to justice dispensation, same as judging and writing judgments is. So since we have more judges here, and I think we are taking baby steps into mediation. So I will try to address the role of judges more than the role of lawyers, on which I think Justice Kurian Joseph expounded largely yesterday, and Justice Iman Ali was talking about it to you. So we have all understood that mediation is a voluntary, non-adjudicative form of dispute resolution. In India, Section 89 of the Code of Civil Procedure includes conciliation, lok adalats, and arbitration as well as alternate dispute redressal mechanisms. But there is nothing which is more important than mediation, because it enables the parties to negotiate and arrive at a settlement on terms which both of them suggest and are agreeable to, rather than something which is imposed on them through the aegis of either a judge or a mediator, or even in lok adalat. And it is a neutral, a neutral third party who is trained in mediation assists the parties to reach an amicable solution, through both negotiation as well as facilitation. So, who is a mediator? He is somebody who is a process expert who understands both communication as well as dialogue. So, you may be wanting to mediate and arrive at a settlement, but if you're not able to converse with the other side or share what you want to say, you'll have a problem. So, this is where a mediator steps in and helps parties to start a conversation. Mostly parties who are in court, especially in matrimonial disputes, as many of you judges would have seen, parties are not willing to talk to each other even. So this is where the mediator helps in getting the parties to talk to each other. In the Indian law, Justice Kurian Joseph, I'm told, has spoken to you. But towards what is an additional step which we have taken in India, which I have been talking to Justice Iman Ali, and I hope Mr. Gosai and the other leaders in mediation will take up, is the strong practice which has developed of court annexed mediation. If you have mediation centers annexed to the courts where judges or the court maintains some degree of involvement, I will not say control, then the credibility and of the institution and the integrity of the mediators becomes immediately acceptable to the parties and the litigants. So this will help in your developing a culture of not only mediation, but also pre-litigation mediation. In India, certain legislations have mandated mandatory pre-litigation mediation. For instance, there is a RERA Act which relates to real estate. The Commercial Courts Act postulate pre-litigation mediation mandatorily. And for the Family Court Act, the Hindu Marriage Act, etc., require a judge to mandatorily talk to the parties to see whether settlements are possible. Bangladesh has had a practice of panchayats, salish helping settlements. Then you had formal NGOs taking it up. The Mandaripur Legal Aid Association, Bangladesh Legal Aid Services Trust, Aino Salish Kendra, Nagrik Udyog, the Bangladesh International Arbitration Center, WIMS, the International Mediation Society, all of them have made very, very valuable contribution. Your legislation includes, similar to India, Section 89A in the CPC, which talks of a flexible, informal, non-binding, confidential, non-adversarial, consensual dispute resolution process where mediator shall facilitate the compromise in the suit without dictating the terms. I'm not very familiar with the law in Bangladesh, but I don't know if you have other agencies, other tribunals like the consumer forums, etc. So, I hope this will be interpreted to read other dispute resolution tribunals and forums as well. Section 89C, I was educated last time, permits mediation at the appellate stage. You have the Artharin Adalat Ain of 2003, Section 22, which talks of a settlement conference after the written statement. The Family Court Ordinance in Section 10, 3 and 4 and 13 also talks of the court requiring to fix a pre-trial hearing and attempt to compromise. This is also after a written statement. The Village Court Act 2006, Section 6 mandates that the village court shall hear parties and decide the issues before them. Therefore, that is, the court shall take efforts for conciliation. The Arbitration Act Section 22 provides for scope that at any stage of the arbitration, parties can mediate and settle. And if settled, the tribunal shall record the consensus of the decision as an award of the tribunal. These are salutary and very, very important principles. But what I would point out is that the stipulation that this has to be done after the written statement, I hope with the Supreme Court and the constitutional courts will interpret it to say that it can be done at any stage of the proceedings. Sometimes it is ideal to not bring a written statement on record because a written statement results in, especially a matrimonial case, if the wife has filed a divorce case and the husband files a written statement and makes allegations, the wife will say, nothing doing, I will not compromise with you under any circumstance. So probably we must look at the stage at which we must take it to mediation. The disadvantages of litigation, as you have realized, is the protraction in the dispute resolution. The judge population ratio in our countries is very, very poor as compared to the West. This is largely because of the population and the number of people who are approaching courts. The costs of litigation, lawyers' fees, court fees, impedes access to justice in courts, especially for women and the poor. Women, in any case, are overwhelmed and intimidated by formal court structures, and so therefore are at a negative, at a lower pedestal or position where seeking approaching the courts. There's a lot of family pressure on women. Don't approach courts. Women who are victims of domestic violence maybe just be homemakers and may not have any financial support. So all these are barriers to people accessing the formal court system. And mediation provides a beautiful platform. The most important thing that it does is it enables you to develop a communication. The first step that a mediator takes is opens a road where parties talk to each other. So even though you don't settle the dispute, but you leave the mediation process at least willing to see each other's face, agreeing to disagree, and there is total peace. There is more peace, I won't say total peace, more peace between the parties who are more comfortable even about carrying on with their litigation. Also, there is this requirement in this stipulation in section 89A, which mandates that the judge does the mediation. I found this in California. In the United States of America, every state has its own laws, but you could not be a mediator in a case which you were adjudicating. So, this we have to look at and ensure independence of the mediators. This is because during mediation, parties bring out information which they have not filed on court record. So, if they bring out material and evidence and things which they haven't said on court record, and the mediator is the judge, he or she may get prejudiced by such information, and the whole basic premise on which mediation rests, that is of confidentiality, will be lost. So we must take care and ensure that these primary principles on which mediation is governed, and these are coming from the experience of places where mediation is entrenched and it's a well settled mode. Now coming to the topic that I have to speak on, that is the role of the judges. What can you do as a judge? First of all, undertake an objective and a detailed exercise of understanding what is mediation. You have a primary role as a judge and part of the judicial system to sensitize everybody, your staff, the lawyers appearing before you, and the parties in understanding the need and purpose of the mediation. You have to then, we are so trained, I have just recently retired, but as a judge, we are so trained in deciding disputes that we ourselves have to sit back and develop an attitude which is favorable and enables us to use the mediation process in settlement of disputes. I know of a lot of judges who are very, disposal oriented in the High Court, were obsessed with the number of cases they decided, who completely oppose mediation, saying that it reflects an inability of a judge to decide the case. I think this is really ignorance and not understanding the value of the mediation at all, which is absolutely important and more beneficial to the society. It is also more beneficial to the judicial system because, it takes away appeals from the judicial system. So a lot of work of the appellate court would be reduced if we encouraged mediation and arrived at settled disputes. Because if you have arrived at a settlement, the litigation comes to an end and nobody's going to file an appeal against a settlement agreement arrived during mediation. So what should a judge do? Make every endeavor to educate parties and specifically refer cases to mediation wherever you think there are elements of dispute resolution. You must objectively determine the possibility of a settlement of disputes through mediation. I will in a little while just advert to which are the cases which we have found more amenable to mediation. No, but in order to be able to successfully do this, you have to develop a belief in the process of mediation. And to develop a belief, it should not only be cosmetic or from the, from the lip service kind of a cosmetic belief, but you must know and understand completely the process of the mediation. So, the importance of judicial awareness and judicial support cannot be undermined or overstated. The more you realize this, the more you will contribute to justice dispensation as well as the society. If you display belief in the mediation process, you will inspire the parties and you will be performing a seminal role towards enabling party confidence in the mediation process. For this, you have to groom the parties. You have to engage with contesting parties and prepare them for mediation. You have to encourage them that they must actively engage with each other and the mediator in order to have a positive outcome towards the mediation. And most importantly, what the parties will understand best is the benefits of the mediation over a protracted trial, and what they will be apprehensive about is whether they would compromise with regard the impartiality which a judge brings to dispute resolution. You must build the confidence in them that the mediator is not only impartial but maintains complete confidentiality. I have found that I have been able to persuade parties at even the appellate stage because of the efforts made either by me or by other judges before whom appeals were found. You have to place mediation on an equal, almost equal, if not equal, pedestal as the litigation. Many studies have shown that, and they established that judges across jurisdictions, not only India, but across the world, have played a fundamental role in advancement of mediation. Mediation, we are the ones who are most exposed to contesting claims and disputes between the parties. We are best placed to, inculcate confidence and inspire parties towards mediation, towards settlements. So the most important thing now, what is the other step that you must be familiar with or careful about is that all disputes are necessarily not capable of dispute resolution. So you need to have the capacity and train yourself to discern the possibility of a dispute resolution and conciliation through mediation. This you have to objectivity, you must maintain an objectivity while determining the possibility of a settlement. You, as I've said, you have to overcome your own proclivity against against the proclivity which we have towards the adjudicatory process, and we towards this, judges and the court system has to work towards proper training and sensitization about the process of the parties. The first, I'm repeating this is very important. The first and critical roadblock to strong mediation is the role of the referral judge. It's you alone who can mold the party's perception about mediation, which can influence and control their willingness to cooperate or be disruptive or non-cooperative during the mediation. You can address the lack of cooperation and ensure that parties enter mediation with an open mind. You will often find that there are some hardcore litigants or such difficult cases where a mediation is returned to you unsettled. Here, you may need to proceed with the case for a short time, take the parties to another point where they are more amenable, are able to see the pitfalls of litigation, are able to see the value or the percentage of success of the case better, and again send them to mediation. So you can send the parties again and again to mediation to so that a positive outcome results by negotiation between the parties. So when can a referral order be made by you? This can be made only if the parties are willing for a settlement, or parties are not willing for the settlement but are willing to explore the possibility of a settlement. And first and foremost, you have to be satisfied about the existence of elements of settlement in the in the case. So, which are the cases which you can send to settle for settlement? So I actually have some slides, but I did not have them. I had not shared them, so I'm unable to show them to you. Perhaps in another training session, I'll arrange that I can share the soft copy of the slides. So, which are the cases which we have found best suited for settlement? These include cases relating to trade, commerce, and contracts. Disputes relating to specific performance, that is immovable property, banker and customer disputes, with property developers and customer disputes, landlord and tenants disputes, disputes between the insurer and the insured. Then also there is another category of cases which can be resolved by mediation. These include cases which result litigation which results from strained or soured relationships. These include, for instance, disputes relating to matrimonial causes, maintenance, custody of children. Then also you may have a lot of litigation. In India, we have a lot of litigation relating to division of property between family members. We have the Mitaksha, we follow the Mitaksha Hindu law system, co-partners, co-owners, then disputes relating to partnership among partners. These cannot get resolved for decades together unless a good mediator is able to take them in hand and get them decided. Then there are several instances where there may be a need for continuation of the pre-existing relationship between the parties despite the disputes. For instance, a fight over use of a passage between two persons occupying different floors of a property, or a dispute between two neighbors. You have a dispute, but you have to live in the same place. So you may be willing to have a negotiated settlement because you have to continue your relationship as neighbors. Then disputes between employers and employees. Also, membership disputes or disputes between members of societies and associations, as well as apartment owners. These are very, very amenable to dispute resolution. Then all cases relating to tortious liability are best suited for negotiated settlement in mediation. These would include, cases relating to mediation, the mediation in motor accident claims, for instance. The dispute between the insured person and the uh, the victim. Then there are those cases where parties seek to avoid unfavorable judgment, or a litigant does not want to appear as a witness, plaintiff or a defendant, and he sees a negotiated settlement as the best way out. Or the cost and time of a trial, a decade long trial, is certainly less conducive or productive than a mediated settlement. But what you must ensure is that pass orders when you refer to mediation and making it a time bound process. Mediation cannot be used as a tool for delaying trial. And A lot of judges we have found, there have been instances, not a lot, where merely to avoid deciding a case, a judge sends the case for reference. This is not acceptable at all. Now there are, while I must point out the category of cases, you have to decide whether there is an element of settlement in a case or not, and only if there exists some possibility or element of a settlement that you will send the case for mediation. So, which are the cases which are not best suited for mediation? These include cases where parties refuse to negotiate and insist on a judicial determination. Then also where there are cases where deciding the case contributes to a development of a new proposition of law. These also you should see whether you should or should not send to mediation. Or a case involves disclosure of some sensitive and private information, parties may not want to mediate. Then there are cases which involve multiple parties, 20, 30, 40 parties. Many of these involving multiple parties as well as multiple issues may not be best suited for reference to mediation. Or parties do not have sufficient information to enable an effective negotiation or settlement. Definitely cases involving statutory interpretation or interpretation of constitutional provisions or of regulations and bylaws or where public policy is involved should not be sent to mediation. Cases where government is a party, no government authority will agree that they do a negotiated settlement in a mediation process. So definitely not amenable to mediation. Then there are sometimes prohibitions by statute which cannot be sent to mediation. Then also suits for grant of probate or letters of administration. I presume we have similar provisions in Bangladesh regarding succession. So these also the jurisdiction is vested in the court and cannot be delegated. And also then disputes relating to elections to public offices, you cannot send them to mediation. Cases which are representative suits. We have Order 1, Rule 8 of the CPC here, which involve public interest. You cannot send to mediation. Then cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, these cannot go to mediation. Then, you have claims against minors or cases involving minors' property. There also, the court is required to adjudicate, definitely, to ensure the welfare of the minor. Criminal cases, complicated cases and constitutional matters, these are those which cannot be sent to mediation. Also, say instance cases involving adulteration of food, wanton pollution, where the conduct of the other side is socially dangerous, you would not send. So this is the assessment which you would undertake is of seminal importance, and you must undertake this exercise before you take up a case in order to send the parties or not to send them for mediation. The potential of mediation, I would like to emphasize, lies across case types and also your understanding of the stage at which you have to make the reference is imperative and very, very important. So I have found that a good judge exercising very good tact can convince any party, no matter how recalcitrant that party may be, to attempt mediating a settlement, even in complicated and unconventional cases. Also, it can be done at even an appellate stage, where one party has a judgment in their favor and may have hardened their position. Judges are best suited to guide parties to bridge the communication barrier. The first casualty when a dispute arises is that parties stop talking to each other. they're not willing to wish each other. They don't want to touch, acknowledge the other party's presence even when they're appearing in court. And, all values and all respect, for parents or brothers or husband or wife, sisters are lost once you start fighting, be it a divorce case, be it a property matter. Good partners who have existed as in partnership business for decades together suddenly may have a fight over some trivial accounting error or misunderstanding, and not only bring the business to a complete grinding halt, but not want to see the other's face, not bothered about the losses or damage that they're causing to each other, monetary as well as of the relationship. I found that I can tell you what you can do sometimes in cases which are non-negotiable. For instance, a murder case cannot be resolved between the victim's family and the murderer. But I had an appeal arising out of a murder trial in which the case against the accused or convict was that he had murdered, got hired contract killers, and got her sister's husband murdered. The motive was property left by the siblings' father. They were also in civil litigation. When the man had been awarded a life sentence, the sister had filed an appeal seeking enhancement of the sentence to death sentence. The case used to come before me. There were 4 contract of the persons alleged to be the contract killers. There was an appeal by the brother. The sister had filed an appeal for enhancement of sentence. So I used to have these 6 appeals. All the convicts as well as the sister used to come to court. And the atmosphere in the courtroom used to be so charged. The brother and the sister could not see each other's face even, and it was a terrible set of affairs. So I just started having a comment once when the lawyers were not there and we were waiting for the lawyers. I started chatting with the sister in the courtroom. We were a division bench. I had a brother judge sitting with me, and I started asking the sister about the dispute. I let her speak about the murder. She made all kinds of allegations against the brother. She really wanted to vent her ire. And this itself is very important. It gives a lot of release to the parties. Then I started asking her as to what was the motive. So she started ranting about the property that her father had left and how greedy the brother was. So then I slowly geared her towards, why don't you look at settling how much was the family size? She had 2 one school going, one college going son. Then I took her towards, why don't you resolve the matters? So she thought I was asking her to settle the murder. And she started yelling and weeping in court that no ways could she compromise with the husband's murderer. So I had to reassure her that I was not asking her to resolve the murder case, which would stay where it was. And we would decide this in the appeal. But to look at the resolution of the civil disputes. To cut a long story short, it took many dates, many hearings. I had to call the sons. I had to talk to them that they needed the money. They wanted to study abroad. They needed the money today and not 15 years later when the civil dispute would get resolved. And without compromising on the criminal case, they agreed to go to mediation. The happiest moment was when the mediator reported that how this brother and sister, the brother used to be produced in handcuffs by the police before the mediator, was sitting shoulder to shoulder, dividing their property, deciding how they would negotiate, how they would settle the property dispute. I don't know what the outcome of the case was because I went to Jammu and Kashmir from the Delhi High Court, and my successors would have decided that. Then there was a matrimonial case in which there were 28 cases between the parties of every kind possible, including allegations of fraud by the husband in seeking his employment, and the young girl, did not have money to fight or engage the lawyer. She used to carry all the briefs in a backpack and come to court. And it took a little persuasion, but I was able to persuade them to. There were defamation cases, there were criminal cases of dowry demands, there were all kinds of every dispute possible. The gentleman was a government officer; he was an income tax officer. the girl was had been a PhD student and had been a professor. When all of it she gave up when she got married, believing it that the marriage would be fair. Unfortunately, the man was already married when he married this young girl, and her life was in shambles. So I persuaded her to resume her studying. She did law, and I'm told today she's probably practicing law. But we were able to send her to mediation, and the mediators helped her settle. The man bought her a flat in a colony near where her brother was residing, which gave her security of shelter and some amount of money. Certainly not very, very much, but she was persuaded, and we told her that she must get empowered and get her own job and build her own life and forget all this litigation, which was the bane of her existence till that day. A 30-year old property dispute between a father, two sons regarding a host of properties in Delhi was settled. It was the old father came in a wheelchair into my chamber. I didn't resolve it. I sent them to mediation, and I only had to groom them, explain to them. They would come to me and seek my opinion, ironing out difficulties, which I did, which was resolved. Unfortunately, the day the wall was built, dividing the father's house into two portions was what took the old man's life. But certainly he saw a resolution of these disputes in his lifetime and must have departed a very peaceful man, in the sense that the disputes and the litigation had come to an end. So, as I pointed out in the beginning, that judges have the most important role in ensuring mediation in a healthy manner. So, what can you do positively? What steps you can take to build up an effective mediation culture in your country, in your courts? You have to ensure that you are able to create some court annexed mediation centers. Mediation centers which are attached to the courts. In our district courts, we appoint judges as the secretaries who are in charge of the mediation center. The mediators are lawyers, but the case assignment is done by the judges, and often the mediators and the parties seek the secretary in charge's assistance wherever they hit a roadblock. But the presence of the judge, who does only these mediations in Delhi, this is who looks after the mediation center, is absolutely salutary. It ensures so much discipline in the mediation centers. We give them administrative office. They have stenographers to write the agreements, maintain diaries, etc. So you have to ensure that the credibility deficit and some discipline is maintained in your mediation centers. The court has to take the responsibility. And Justice Iman Ali, I'm sure you will do the needful and undertake this exercise on war footing. Please persuade the Chief Justice to call upon the government to provide the necessary budget also for creating the necessary infrastructure for mediation. We are doing it as part of our legal services in India. The budget for the legal services, part of it is allocated for mediation facilities. You have to ensure quality mediators and facilitate the growth of lawyers specializing in mediation. You have to persuade lawyers to take to mediation, pointing out perhaps we in India can assist Bangladesh in undertaking such an exercise. We have very good, we faced an opposition from lawyers in the beginning who thought that mediation would cut into their livelihood and their income, and they had to be persuaded to take to mediation. So from Delhi, we can send you very, very competent and able mediators who are senior lawyers who are practicing litigating in courts, as well as doing very good work in the mediation. In Delhi, we have a organizing committee which is headed by a 4-judge of the High Court committee, assisted by an organizing secretary of the mediation center, 2 senior advocates, and a couple more lawyers. The organizing secretary is a lawyer, and the 2 senior advocates are lawyers, trained mediators. So you must help lay down standards and ethics. Since mediation process is not codified, but we can lay down protocols. We can prepare norms for training. So this is very essential. This is an exercise which we can undertake. Probably BIMS can take it up even before court annex mediation is taken up by the courts in Bangladesh. And a process for accreditation of lawyers, which must include the power to strike off somebody's name from the approved panel of mediators for violating any of your protocol or any ethics or confidentiality requirements. This power must rest with an appropriate authority. The monitoring has to be regularly done, and this can be done by any senior judge of the High Court or the Supreme Court. So, this will reinforce faith in the mediation. As I said before, ensure credibility and integrity of the mediators and ensure the purity of the process, which is integral to a healthy and robust mediation. And lastly, but most importantly, is giving publicity to the process and benefits of mediation through enhanced and effective data dissemination. So we have to develop jingles, take out advertisements. Your legal services authorities can go out into the public, and we must ensure that mediation as a tool for dispute resolution is made public and known to the people. Now, what Delhi, India has been grappling with is a question as to whether you need a legislation or not. The process of mediation, whether it should be codified, qualifications of mediators, the trainings, then laying down norms of ethics, confidentiality, as well as neutrality. Just like the Arbitration Act requires a disclosure, in the Arbitration Act in India requires a disclosure by the arbitrators, we have to provide for such requirements from the mediators as well. And then a very important, integral and critical part of mediation dispute resolution is drawing up a mediated settlement. The mediated settlement has to comport to the requirement of law, must meet all areas which were under litigation and stand disputed, and has to be workable. You cannot have an agreement which is contrary to law or which cannot be executed or worked out. And when you're talking of legislative guidance, the legislation must make out the enforcement. Where would how would the mediation settlement get enforced, and its execution procedure must be clearly stipulated. So there is one more problem we've had in India, that there are several cases, criminal cases, which are quasi-criminal in nature. Say, for instance, check bouncing cases under the Negotiable Instruments Act, Section 138, or disputes between directors of companies, or criminal cases arising out of family matters, say a dowry complaint, and the parties decide to come together, a husband and wife, ignoring the previous disputes. Then civil disputes, which are between parties who are parties to serious criminal courts, like what I just pointed out to you. So what would happen if you were to send these cases to mediation and they got resolved? Where would the settlement in these cases be placed and executed or worked? This is something which I think you in Bangladesh can anticipate. One of these issues was placed before me in a reference by a magistrate who was concerned with a mediation settlement in a criminal case arising out of a check bouncing, which settlement one of the parties violated. So the matrimonial judge was in a fix as to what were his options, and he referred questions to us in the division bench, which are decided by a considered judgment. So, there is also, say, for instance, a petition seeking appointment of an arbitrator. In this, the parties are willing and say that they are willing to go to mediation for their disputes. They go to the mediation and they enter into a settlement. And because the matter is settled, the arbitration proceedings are closed and the matter is disposed of. But if the parties fall out and there is this dispute as to how the settlement has to be worked, then which is the court which would have the power to force the parties to stand by the arbitration agreement? You know, the arbitration agreement, the mediation settlement in those proceedings was not part of any court proceedings, and therefore no contempt of court, no execution would lie. And this is another area which is vexed, on which also I had occasion to write a judgment in the Delhi High Court. We looked at this problem in Jammu and Kashmir while I was there, and the government there has legislated and said settlements out of mediations would also be enforced as awards. That's the provision of law there. So perhaps in Bangladesh you could look at this area as well. Now, but while you're legislating, you need to ensure that you have that freedom is given to mediation centers to frame their norms and rules. And most imperatively, a specific budgetary allocation is needed for every court for undertaking mediation, with the freedom of the specific court to decide how and where it should be allocated. Because only the court concerned would know what it needs to do, how much it needs for what. If you don't have a building, you'll need to get a building constructed. If you have space in the existing courtroom, you may need only a few tables and chairs, or a few computers. So all this, and then you have to provide the manpower. Also, there is this business of pre-litigation mediation. You know, a settlement which is arrived at, now pre-litigation mediation will reduce the burden of the courts in a big way. It has been misused in some of our family litigation. Some lawyers use it as a tool for extracting information about the other side's case from the other side. So we as judges have to be very careful, or the mediation center here has to be very careful and guide the parties as to how much and what they should reveal. Probably have independent caucuses to decide what is to be done with the mediation. But it is imperative to know where a settlement at the pre-mediation stage has to be placed. Now, lastly, my last point is that what happens when there is a settlement? Where is the settlement to be placed and how it is to be treated? You know, first of all, when a mediated settlement is brought before you as a judge, you have to see that it does not violate any provision of law. You must see that the settlement was between which parties, all the parties, and whether between some of the parties. Then whether the settlement covers all the issues or it's only a partial settlement. But before you reach this point, you have to be first and foremost satisfied that the settlement has been voluntarily arrived at between the parties signing the settlement, that the settlement is not collusive or illegal, and most importantly, it is executable and is workable. You must ensure that the parties or their authorized representatives are there when you are looking at the settlement. Then what you have to be ensure is that sometimes you may need to modify or amend the terms of a settlement to overcome some technical or procedural difficulty in implementing it. And you know, I'm sure that in Bangladesh also you have a provision akin to Order 23 of the Code of Civil Procedure in India, which tells a court as to how they will record a settlement between the parties. You must comport to the requirements therein, signed in writing, signed by the party, voluntary, lawful, all that. You must, and then pass a decree in terms thereof or an order thereof. In criminal cases, as in 138 of the CPC, I said that the court must pass an order in terms of the settlement and direct the parties to remain bound. Then it became an order of the court, which, if violated, the court could enforce if it was for recovery of money as areas of land revenue under a code of criminal procedure. But please look at the judgment which we passed in the court reference in a case called Dayavati. And the settlement in a arbitration petition which was not placed before any court had dealt with it in angle infrastructure. And you can look at, I will request Mr. Goswami to circulate these judgments to you, as also the two judgments of the Supreme Court in what are called the Salem Bar Association cases. The second Salem Bar Association case is very important, which made mediation process of the Salem Bar is of the Supreme Court, made mediation in Section 138 of the Negotiable Cases, Negotiable Instruments Act mandatory. But of course, there is no statute regarding where a settlement in a compoundable criminal case has to be placed, because the Criminal Procedure Code does not talk of a mediation or a settlement. So, perhaps the Supreme Court of Bangladesh needs to interpret the law and lay down the principles which we in India have in the form of judicial precedents from the Supreme Court in Salem Bar and the two judgments of the Delhi High Court in Dayavati, and the other third case is the Angle Infrastructure. So, this was my summation of everything that a judge should be doing and needs to do while ensuring mediation. You will not only be careful while referring a case, but maintain a tight control over the mediation in directing that it shall be time bound and extending the time by very limited periods if the mediator requests so, and ensure that the mediation is not used as a tool for diverting, delaying, or digressing from the litigation, or is not being used. And the judges must ensure that they don't use mediation as a method of avoiding adjudication. You may sometimes have settlement of some of the issues. Then the judge has to decide those issues which remain unresolved. And also, there will be cases of no settlement. Here, the court cannot ask for the reasons why the case was not resolved. There is complete confidentiality attached to the mediation process. But the court proceedings have to continue in accordance with law. And also, nothing stops you as judges from trying to settle the dispute again and again. Thank you very much for giving me this opportunity for sharing my thoughts and my experience as a judge. I reiterate that I have found it the most important tool in dispute resolution, as much, if not more important than adjudicating or writing judgments. Thank you.
Thank you, ma'am, for your comprehensive discussion on such an important topic. Ladies and gentlemen, this is the question answer session. If you have any query, Honorable Justice Geeta Mittal ma'am is here to answer. Feel free to ask. Yes, sir.
I have a point of clarification, if I may.
Yes, sir.
Justice Geeta Mittal, if I can just read you what Section 89A says in our law. The difference you will see is that our law, your law was changed in 2002, ours was changed in 2003. But then it was further changed in 2012 and again 2017. And that we have then gone away from the Indian type of law. And if I could just read it to you. Except in a suit under Artharin Adalat Ain, after filing of written statement, if all the contesting parties are in attendance in the court shall, this is the important part, the court shall, by adjourning the hearing, mediate in order to settle the dispute or disputes in suit, or refer the dispute or disputes with the suit to the concerned legal aid officer or to the engaged pleader or parties, or to the party or parties where there is no pleader, or to a mediator from the panel as may be prepared by the district judge under subsection 10 for undertaking efforts for settlement through mediation. So the distinction here, as can be seen, is that after the written statement, the court shall adjourn and send to mediation in different forms, either by itself or the legal aid officer, etc., etc. So there is no question of the court at that point in time making any assessment whether the case is suitable or not suitable to be sent to mediation. The court shall immediately on filing of written statement adjourn the case and send it for mediation. What I would suggest perhaps is that the judge should say, we are bound to send you to mediation. Let me fix a date, bring the parties. Next time I will tell you exactly what you must do in the course of that mediation process. And I think that's when we can tell the parties, including the lawyers, what it is, what mediation is all about, confidentiality, impartiality, the informal nature of it. So all these can be told to the parties in presence of their lawyers at that next hearing, when it will be gone into detail as to what mediation is and the benefits of the mediation. As I said at the very beginning today, when I think Justice Geeta Mittal wasn't present, but I told everybody that in that meeting, the court must tell the lawyers, the parties concerned, the benefits of the mediation. It's no good just saying, I'm bound to send you to mediation, go to mediate, try to do it. If you don't do it, come back. That's not the way to do it. The thing that must be done is to tell the parties all the benefits that will accrue by mediation, saving time, saving money, having peace, and coming back with an agreement, and that will become the decree or order of the court, and that is not appealable. So saving further cost and further harassment. And if you develop the relationship between the parties, then of course, that is the end of the matter, and you can continue with your business. The other thing that I want to clarify is that we don't have any scope for pre-trial mediation. So before the written statement, nothing can happen. But we do have the system where the parties can go directly to the legal aid officer and discuss their case, and he will assess the viability of a case. And then if he agrees that there is a case to answer, then he will mediate. So that again forestalls any future litigation, because the legal aid officer will immediately do the mediation and it may settle there and then.
The pre-litigation mediation doesn't require a legislation. You know, we just have to put in the system for pre-litigation mediation. Whether you need the system as a formal system or a statute would be the enforceability. Otherwise, it just becomes an enforceable contract, you know. So also what we have found is that, the legal aid officer and the judge are really judges who are trained in adjudicatory systems. As I discussed with you on the last occasion, that it's imperative to train every judge in the mediation process, because only they can be useful as referral judges. Even though you have a provision which mandates, we have also got several statutes where it's mandatory, you know. The Commercial Courts Act, RERA, Family Courts Act, it's mandatory to refer to. But two things which I pointed out, I'm conscious of the requirement of your statute, which says, I commented on this, that it's not, sometimes requiring a written statement before sending to mediation is counterproductive. I have found that in almost every matrimonial case. You know, the disputes get so exacerbated if you get the written statement that, you know, what could be parties willing to talk to each other. The written statement brings in even more allegations in a matrimonial case against the petitioner than she or he could have ever contemplated, that they will not sit in the same room with each other, let alone across a mediator's table. Then the third thing which I pointed out, I'm conscious, that's why I pointed out this requirement of, perhaps you may look at, reading the shall as may, because there are certain disputes which you cannot send to mediation. A representative suit, Order 1 Rule 8, trusts, there are prohibitions under several statutes, and the nature of disputes in several cases, interpretation of statutes. So you and the Supreme Court may need to interpret. If you look at the Salem Bar Association case judgment of Justice Ravindran, what they read in mandatory mediation in Section 138 of the Negotiable Instruments Act, which provides for a criminal prosecution of a person where a check gets dishonored for certain reasons. And the Supreme Court of India has interpreted, has read in mediation as mandatory in those cases, and also in some other cases like a dowry complaint, Section 498A of the Indian Penal Code. So, sir, here is where we would need some proactivism from the Supreme Court, sir, because a judge must have discretion. If you say that the moment a written, sometimes you may feel the need to send the parties to litigation after you've recorded the plaintiff's evidence. A plaintiff who filed a case and then balks at coming into the witness box may be willing to settle a claim of, say, 1 crore for a few lakhs, only because he's nervous or scared to come into the witness box. And that may be the stage to send them to mediation. So insisting that you can go to mediation only after written statement, sir, is actually narrowing the scope of mediation. That's what I was pointing out. So that's absolutely imperative that you give the discretion to the judge to decide the issue of whether it's fit, a case is fit. All disputes, as I pointed out, sir, cannot be referred to. And this has come from experience of not only our country, but across jurisdictions, sir. Like California and several other states in the US have very robust mediation mechanisms. And we've examined their experience, etc. So to come at this, the enumeration of cases which I pointed out, and our experience in India. And the third important aspect, sir, you can't be a mediator in the case which you're trying. That's the principle on which mediation has commenced in the US. You may need to correct your system, but sir, judges should be conscious of the pitfalls and in sending every case. You will lose 1 or 2 days, definitely, even in a critical case in sending a case to mediation. For instance, somebody asks for an interim injunction. The judge says, I can't give it to you ex parte. I have to get the written statement. He gets the written statement, then the defendant says, now I filed the written statement. First, we have to go to mediation. And the urgency of the case may require, before maybe a mediation order, but certainly the injunction, so the criticality of the case. So the discretion, and then there may be cases you sent it for mediation after written statement, it comes back unresolved. So you need to send it again and again, sir. So, that discretion is very important. So, sometimes too much codification or tying a judge's hands, doesn't have the best results, sir. And what I must say, sir, you need to, we must start a mediation training process for judges, sir.
Yes, thank you. I agree with you that it's not necessarily so that mediation can't be done at any other stage, because even the law allows mediation at the appeal stage. And I agree with you that even during the trial, there may arise, after ironing out some of the issues, which may be resolved in the course of the trial. Then if the court feels that there is a need for mediation, then it can be done, I'm sure. I don't see the problem with that. Thank you.
So, some elements of may need interpretation, The shall may need to be read as may in certain instances. I'll forward you a copy of Salem Bar Association, sir, if it hasn't come to you.
Thank you.
Thank you, Geeta Mittal ma'am, for your marvelous reply, and Honorable Justice Imanali sir for your valuable question. In this time, I would like to invite Mr. Kevin Berry Brown, Course Director of Bangladesh International Mediation Society, Ombudsperson of United Nations, and Green Climate Fund, IMI Qualified Assessment Program, IMI Certified Mediation Training Program, President of Mediation International, to describe the role of mediators. Kevin Brown, sir, are you there?
Yes, I am.
Okay, sir.
I'm just setting up my, hope you can see that. Bear with me one moment. I'm just getting my slide ready. So thank you. Thank you very much. Good morning, good afternoon. I understand we have somebody from, it's up at 2 a.m. in the morning. Thank you so much for coming. It is now about 8 o'clock here in the morning. So it's still early morning for us, and it's mid-afternoon, I guess, or just before lunch for you. I am thrilled to be here. I want to say good morning, particularly to all of the justices, the mediators, lawyers, judges, participants, esteemed speakers, and of course to BIMS for organizing all of this. To Mr. Goswami, you've done an amazing job again. I'm very, very happy to be here. What I think makes this very interesting for me in particular is the fact that I'm here with so many like-minded people. I mean, I've been to other conferences and people come with very different opinions on what mediation is, but everybody is saying pretty much the exact same thing here, and I love that. There is some repetition, and I think repetition is good. I heard my colleagues, Priyanka and Tanush, I'm going to say her name wrong. I apologize, Tanushri, speaking about mediation yesterday, and some of the things that they were saying, I also would like to speak about as well. Justice Iman? I think I'm saying that right now. I apologize. Was also speaking as well as Justice Mittal this morning about mediation, and I will probably repeat some of the things that they were saying, but I will skip over some as well because I know we're short of time, and I won't repeat too much. As I mentioned, I'm Kevin Brown. I've been a mediating and ombudsing for well over 30 years now. I started off in Canada, and I'm now in Madrid, Spain. I started off doing family mediation, then I moved into community, civil and commercial. I did police mediation, court mediation, criminal mediation, and then I found my passion, and that is in workplace mediation. And I'm now doing workplace mediation and international mediation with the United Nations and Green Climate Fund. Because of COVID, I mean, I do all of my work from home here in Madrid, but we have enough technology available to us to do these types of webinars as well as mediations online. I don't know how many mediations you folks will be doing online, but I've been asked to speak to face-to-face mediation, so I'll do that today. I hope I don't lose my voice. I'm starting to. So I do want to talk to you about a number of things. I want to start off maybe by sharing something that's already been shared by others. And I want to talk just a little bit at this point about mediation stages. And, depending on whom you speak to, there can be 5, 6, 7, 8 different stages to mediation. They're all pretty much the same, in my opinion. It's just how people divide up the work, divide up the stages. Myself, I like this model here. It's a 5-stage. I start with pre-mediation, and I think that's something some people don't do, and at least including it in the mediation process. I include it simply because I do most of my work at the pre-mediation stage. Well over 50% of a mediator's job, at least in my experience, is done at the pre-mediation. What we're doing there is we're talking to the lawyers, we're talking to the clients even, and getting the parties ready to be able to meet with the other party. Oftentimes people have been in conflict for a long time now, and they haven't spoken to each other. The lawyers have kept the parties separate in many cases, and perhaps the lawyers have been speaking with each other, but the parties really haven't. And I find this opportunity, the pre-mediation stage, to be a great time to be able to get the people prepared, help them prepare to be in the room with the other person. When I'm doing mediations, as I said, a lot of the work is at the pre-mediation stage. And that work for me is getting them ready to listen to the other person. Everybody wants to go in and talk. They all have their side of the story. They all want to share what they have, why they are right and the other person is wrong. But my job before the mediation even takes place is getting them to the part where to the point where they're ready to listen to the other person. I then go into the initial joint session. And I call it the initial joint session because this is probably the most important session of all. There's also a joint session next, which I'll mention in a minute. But in the initial joint session, that's the point where people get to hear from me. They get to understand my role. They get to understand what I'm doing there. And they also get a chance to speak. I'll go into more details in a moment. I just want to give you an overview here. I then make a decision, and that decision is based on the lawyer's input and my own opinion based on meeting the people in the initial session. And my decision there is whether to continue the session. Sometimes there's benefits and other times it's a disaster. So it all depends on your clients and the decisions you want to make. Oftentimes I will go directly into caucus, have the opportunity to speak with people. They will be there with their lawyers, separate rooms, and then I will do what I call a shuttle mediation. And then it gets to the closure. I have 3 types of closures: fully resolved, partially resolved, and not resolved. And that is all the information I ever give out to anybody else. And my participants know that. The only other occasions where I give more information is when the parties have agreed in writing in the minutes of settlement that they would like me to share more with whomever it happens to be. So, overall role of the mediator. Sorry. So the role of the mediator is has been mentioned the last couple of days, so I'll very quickly go over it. Facilitating the discussion between the parties, helping the parties reach a satisfactory outcome in confidence and in the spirit of trust. The mediator is not a judge. They don't take sides. They don't tell the people who is right and who is wrong. They are there to create an opportunity for the parties to have a constructive dialogue. They do provide professional, neutral, and independent assistance throughout the process. That's overall what the mediator does. The second stage of what I have in front of you here is, well, let's talk about what makes a mediator successful. Now, a lot of research is out there, and the research that I've read and that I adhere to shows that mediators have success globally because of 3 factors. The mediator allows the parties to deal with issues that they themselves feel are important, issues the parties feel are important, not the mediator. They allow parties to present their views fully, and they give the parties a sense of being heard. Using your mediator skills of active listening and questioning, paraphrasing, summarizing to find out what's really going on, what's underlying, what the real needs and interests of the parties are. Huge part of a mediator's job. Now, parties themselves who have enjoyed successful mediations find that what they like the most is the greater degree of participating in the decision making. A judge or an arbitrator is not making the decision for them. They are making the decisions, hugely important to people. The greater opportunity also to express themselves and communicate their views. People want to be heard. Often, they have not been heard by anybody other than maybe their spouse and the mediator and their lawyers. They want the other party to be able to hear where they're coming from. Studies have revealed that informal mediations that lack these features result in lower successes and satisfaction rates. Plus, in my own personal 30 years of experience, every single conflict that I have been involved in or that I have presided over, at its core are undeniably emotional elements. Lawyers and many other professionals involved in conflict management typically believe that disputes are managed through the use of rational decision-making, objective reasoning. However, when a group of experienced mediators were asked what they wished they were taught more of during mediation training, they had a different outlook on it. They said that they would have liked to have had more detailed techniques for responding uniquely to each negative emotion that they've experienced in the mediation. Negative emotions such as fear, anger, shame, jealousy, pain and grief. All of these emotions have come up at some point in the mediations that they've been involved in. They wanted methods for increasing emotional intelligence, ways of becoming more aware and responding to the energies of the conflict. They wanted methods for opening heart-to-heart conversations amongst the parties, knowing how to strike the right balance between head and heart. Now, there's a great book that's out there. It's called Building Bridges Between Psychology and Conflict Resolution, Implications for Learning. This is by Kenneth Cole, C-O-L-E. So if anyone's interested in me, it's available out there. I'm sure you can find it. It's a great book. I have it. It talks about emotional intelligence, and it talks about how you can deal with the different emotions that will come up in mediations. So what this tells us is that experienced mediators found it nearly impossible to separate the emotional drivers behind a conflict from the facts. Conflicts can only be resolved if the underlying emotions beneath them are identified and addressed. Now, this requires mediators to be emotionally literate and possess a degree of what is described as emotional intelligence. A lot of books out there on that as well. An emotional, intelligent mediator must develop 4 skills: the ability to identify one's own emotions and those of others, the ability to harness emotions and apply them to tasks such as thinking and problem solving, the ability to manage emotions, including the ability to regulate their own emotions, and the ability to affect the emotions of the others in the negotiation. Now, mediators have a code of conduct. These codes of conduct differ throughout the globe. And, we see here one of them is voluntary. I know that is a word that's been mentioned quite frequently in the last couple of days. And to be quite honest, for well over 10 years, it's a word that has been debated amongst mediators and other professionals as to the necessity of the voluntariness in a mediation. It is, when I looked on websites right across the globe, voluntarism is one that was pretty much consistent. I would say 99% of the different groups listed voluntariness as a principle of mediation. And then they started to come up with mandatory mediation. And there was a huge debate about that. But, folks, we're mediators. It doesn't have to be black and white. It doesn't have to be voluntary or mandatory. There can be something in between. And that's what I believe Bangladesh has found. And I know places like Italy and Turkey and Greece and some places in the States and some places in Canada, they have come to realize that there are other options. Mediation must remain voluntary. Getting to mediation doesn't have to be voluntary, though. People can be nudged, and I think that's a very small word because the nudging is quite strong. A lot of courts have made the initial meeting or information session with a mediator as mandatory. So you are required by law in many countries, and I believe Bangladesh, to sit down with a mediator for half an hour or an hour, pay a small fee, and decide then if you're going to go into mediation. If you opt out, well, then you're free to go to court. You're free to free to move however you deal with it, however you want. And that, as I've seen, has been a tremendous. In Italy alone, just Italy, others are following suit with very similar. They went from next to no mediations to over 300,000 mediations a year. 300,000. Greece hit 200,000 last year. And these are all because people have sat down with a mediator, an approved mediator, and decided on their own with their lawyers to try mediation as an alternative to going through the courts. Some of the other aspects of the code of conduct include impartiality, independence, confidentiality. Organizations that do have mediators, they have their own set of code of conducts. Many of those have already been spoken to. The mediation agreement, the process and settlement, these are very important factors, in my opinion. The mediator's role is to ensure that the parties to the mediation understand the characteristics of the mediation process and the role of the mediator. The mediator must, in all circumstances, ensure that that prior to the commencement of the mediation, the parties have understood and expressly agreed to the terms and conditions. There's an agreement to mediate that I use it all the time, and it's paragraph after paragraph after paragraph legally written up so that people are fully aware, and they can sit down with their lawyers as needed to make sure that they understand what they're getting themselves into in a mediation. The process must be fair for everybody involved, and at the end of the day, or at the end of the mediation, the parties can withdraw at any time that they want. They don't have to stay there. That's the voluntary aspect that continues. Personally, I put in at the beginning of a mediation, I say to them, says, at some point you're going to hear, I'm talking to the parties here, at some point you're going to hear things that you don't agree with. And that's because there's a conflict. You have a conflict. I want you to wait until the other person finishes, and then it can be your turn to speak. I also say to them, says, you can leave at any time you want, but I'd like you to promise me here that before you walk out the door, you will spend 5 minutes with me in a caucus before you actually leave. I have found that to be extremely beneficial with the parties. People sometimes just get frustrated and want to walk out the door. I also seen that as a strategy to get the other side to believe that either they resolve this now or give in. The party's leaving, and that strategy has worked. I'll be quite frank. That strategy has worked when the other party sees that. Well, we either decide or we don't. It's part of the mediation process. So having that 5 minutes with me alone can make a big difference. Okay, quickly going through the different stages. I'm not going to read that to you. I'll let you read that by yourself, but I think it's self-explanatory. I've said some of it already. Many mediations and pre-mediations are currently completed online because of COVID-19. My focus here is in person, but a lot of the pre-mediation still happens not face-to-face, either on the phone or online. And suffice it to say, there are many elements involved if you are going to do online mediations that are outside of the realm of our opportunity to speak today. I have another entire presentation for people doing it online because there's so many factors that many of us don't realize, aren't accustomed to, that we need to get prepared before we do online mediations. But that's a topic for a different day. Essentially, the pre-mediation is to read as much of the information as you can, read the submissions, learn about what's going on. You are not going to hear from the lawyers in the mediation itself everything that has happened over the past 2 years of how long this conflict has been going on for. You need basically to do your homework. You need to read in advance the important materials, the pleadings, court rulings, orders, legal authority, contracts, depositions, hearing transcripts, anything and everything beforehand in order to be fully prepared for the actual mediation. the ask for the and study the mediation submissions. Speak to the party representatives. Encourage counsel to use mediation, and that's not just to show up because they're there already, but encourage the counsel to use mediation for its best purposes, which is to resolve this. Help get them to prepare their clients to be ready to speak at the mediation. Personally, I don't like to hear only, well, my client is here today because of. I much prefer to hear, I am here because of. So I like to have the parties speak at the mediation. People do it differently, but I'm just letting you know what mine is, how I do it. Before the mediation happens, you have to make sure that you have the right people at the table, the decision makers. And if they're not there, then the people that are at the table need to have the phone contacts, ways of getting in touch with anybody else. There's always somebody else involved, and it's always a pain, awkward to say, okay, so you don't have your decision maker here, so we'll have to, adjourn the mediation and come back again another day. Nobody likes that. People like to be able to resolve it whenever they can. Doesn't always get resolved on the first day, don't get me wrong, but deferring simply because the decision maker isn't here is not particularly comfortable for everybody. This is how I do it. This is how I set up my mediation room. I'm at the head of the table or the foot, whichever way you want to look at it. The two parties are right beside me. Beside them are their lawyers. Anybody else the parties are bringing, any witnesses and any experts that they need to be there. Obviously, you can set it up however you want to set it up. I'm just letting you know how I do it. So the opening joint session, that's my opportunity to speak. A lot of mediators have said to me, or not a lot, some mediators have said to me that they don't do an opening statement because the room is filled with lawyers. The lawyers know this. The lawyers have been doing this for years. You don't need to bore people with your opening statement, and there's very little value in it. I completely disagree. 100%. I think the opening statement is the most important thing that you will do that day. You are setting the stage. You are telling people what your role is, what their role is. You are setting up the day to work the way you want it to work, not the way the lawyers want it to work, not the way the participants want it to work. You're talking about your role, how you are going to run this process. You are in control of the process as a mediator. You're not in control of the people. You're in control of the process. And that's what you need to do. Not doing an opening statement is, in my opinion, a big, big mistake. So you have to let them know why you're here. And you're here to help them settle the case, to create and keep momentum, to change people's perspectives about the case, to determine the party's true views, to help them identify what's going on, and let the other party know the other perspective. Sometimes this is the first time they've actually sat down in the room with the other person for a very long time. You're there to stop the lawyers from, I call it chest thumping. That's when, I think we've all seen it, is when the lawyers are there and they're being more destructive than cooperative. This happens, not often, but it does happen when the lawyers don't fully appreciate the value of a mediation and resolving things. And the lawyers are there saying, well, we're going to win and we're going to get this and we're going to get that. And this is a waste of time because in court you will get this. We all know that is not always completely factual. And it's up to the mediator to prevent that from happening to a very large degree. That's for court. That's what lawyers do in court, and they do it beautifully in courts, and that's what they're trained for. This, though, is mediation, and the mediation should be done in a more collaborative way, to the best way possible. Now, after you have spoken and you've given your perspective and your opening statement, it's their turn. Each party gets the chance in the initial stage to speak without being interrupted. The other party doesn't interrupt. The other party doesn't say anything. The other party doesn't jump in. If they start making noises or grunts or anything negative, you stop them. You remind them. It's also, if they are doing that, it's a good clue that you probably shouldn't continue into the next joint session and go directly into a caucus. They need to allow the other person to speak. That's what the initial joint session is for each person to fully hear the other party. Your role in that is to listen carefully, take the notes, and decide if there's going to be a further joint session. That is completely your choice. You get to make that determination. You need the notes because it doesn't always settle on the first day. Oftentimes it goes over, and to have those notes is very, very important for you as you moving through the mediations that may be required. Joint discussion. This is either the easiest or the hardest stage for the mediator, depending upon the parties. As I mentioned, you decide if you're going to go there. Here's the stage where you're trying to get the parties to talk directly to each other about what they said in the opening statement. And it can be super easy, or it can be really, really difficult depending upon the parties. Now, the easiest is when the mediators and lawyers have prepared the parties to have a frank discussion, and they are respectful of each other. And I see that all the time. And because they've been well prepared and their lawyers has talked to them, the lawyers are on board as to the benefits of mediation. They've heard from the mediator what's necessary from them. We've talked about the benefits, the perils, and the peril is destroying it, everything, and just having it all break down and crash and burn because nobody is listening to the other side. It is their opportunity to reflectively listen and engage in the conversation. After that, or instead of that, depending upon the situation, we have the private caucuses. Now, these are great opportunities. You're able to have private, confidential caucuses with the people. Like it's been said before, everything that you hear or that's said in a caucus stays there. When you're in the joint session, everything is between everybody, all parties, and the mediator. When you're in the caucus, it's between you and the party that's in the room. You do not take anything to the other side unless you've been given express permission to do so. Oftentimes, if it becomes a shuttle negotiation, they will say, take this figure over to the other person, and you can certainly do that in those situations. This is when, the worst alternative, you've heard of BATNA, best alternative to a negotiated assessment. This was mentioned yesterday. Well, there's also WATNA, which is the worst alternative, the opposite of a BATNA. If you don't settle, what's the worst thing that can happen to you and to your case? You might be able to tell I'm trying to rush through this. I only have 30 minutes to speak to this, and I have a lot of slides, but I am going through as quickly as I can. Some of the things that you're trying to do when you're in a caucus is to overcome the resistance, deal with emotions that are there. If people are very emotional, caucuses are a great place to deal with it. Talk privately, ask questions of the parties, do some reality checking with them as to their real position and what their underlying needs are. If they continue to negotiate on the position level, as was mentioned at least yesterday, they're not really likely going to get very far. If there are underlying things, issues and wants or needs and interests, well, then those are the things that you can talk to them about and get them to talk about if you go back into joint session. As far as the caucusing goes, I like to spend the pretty much exact amount of time with each party. I switch back and forth who I start with and who I finish with. And part of my job is to make their transition back into the room, if we're going to go back into the room, as smooth as possible. And that's usually by talking to them about what they are going to share with the other party when we go back. I've talked about most of that. There's a slide there about confidentiality, and I believe it's been said before, but everything is confidential. There are exceptions, though, in all cases. If you're given permission, well, then you're able to break confidentiality, and it's not really breaking confidentiality. The only other exception in my world, and I imagine maybe there as well, but you'd have to check that yourself, is if there's imminent risk of serious harm. If somebody has told me that they have, don't worry about Kevin, I went out and I bought myself a gun last night and I'm going to resolve this myself, that is reportable. None of us want to be responsible for knowing about something that was going to happen, and we allowed it to happen by keeping the confidentiality. The courts in the West and in Europe all support this. I have to imagine it's supported there as well, but you can certainly discuss that. Emotional venting. We talked about some of that already. Doing it in caucus is so much easier than doing it when people are very, very excited. Family situations are like this a lot. Couples that are separating and are trying to divide their assets and their children, and especially when they have new partners that are involved, it can become very emotional, especially if the new partners are there in the room. I try not to have the new partners in the room if I'm doing a family one because of the intensity. It does change the dynamics. The other side of that is that when people go home after resolving things, oftentimes they will speak to their new partner, and they no longer agree with it the next day, and then they call to say that I've changed my mind. Mediator closure. The mediation is not an isolated event. It's not just that day. It can easily go the next day or another day. When I'm helping people, when people are ready to close and they're done, it's the end of the day. As judges and lawyers and mediators, that oftentimes are settled, at the last minute, because people would rather settle than come back, next week or the week after or the next day even. They really do want to settle, and they can give in a little bit more at the very last minute, and this happens. It's not an isolated event. There's ethical considerations all the way through. You've been talked to. My colleagues have spoken about what you can and cannot do on an ethical standpoint. So what I'm looking for, confidentiality, for example. When you do close the mediation, Justice this morning spoke about what you can say to other people. That's pretty straightforward. If you're doing shuttle mediation, it is your job to share the settlement proposals by the other person, whether you agree with them or not. If something is being presented by one side, your job is to present that to the other side. I strongly suggest that you don't close the mediation off abruptly. In other words, if you're sitting in with party A and they say, we're done, end of the day, never just say, okay, thank you very much, I'll let the other party know. If you leave now, they'll leave in 10 minutes. Never do that. Always let the other party know that this first party is ready to leave and they're ready to go out the door. Is there anything that they wanted to say or do before? And oftentimes that is sometimes the momentum to come to some sort of a conclusion. Follow up. I follow up with my mediations, particularly with the ones that don't, but also with the ones that do resolve. I believe that's important. I think it's I build that into my costs. I build that into my process. I let people know that the following week I will speak to them, and whether I speak just with the clients or just with the lawyers. Rarely do I speak just with the clients. If the lawyers are involved, I usually go directly to the lawyer. But I do that because I believe that there's importance in following up and letting people know. So, no, too far. In summary, very quickly, your role is to gather the information. Your role is to actively listen to the parties. And that means sitting there, leaning forward, nodding your head, making noises so that they know that that they are being heard. Summarize what they are saying. Reflect the emotions back to them. When you see somebody crying, don't ignore it. Make a comment. You can pass them a Kleenex. You can say things like, This is obviously very upsetting for you right now. Would you like to take a break? The last thing in the world you should be doing is ignoring them, because everybody in the room sees them crying. And if you turn to the other party and start talking to them, they are going to feel horrible, and you'll never be able to get them back into a negotiating or a collaborative mode because you have completely ignored them. You need to get their story, not the lawyer's story, not the other party's story. You need to get their story out and ask them questions. Probing questions. Dig deep into the question. Ask them why. Ask them how this happened. Ask them how this impacted them. Encourage them to resolve. And finally, draw out the background, clarify your understanding, all what I've already said. Be aware of nonverbal cues. Our words represent only about 7% of the way we communicate in face-to-face. The rest is built up of paralanguage, how we say it, the tone we use, how we reflect it, the emphasis we place on it, and as well the body language. Body language is huge. I think body language fits in at about 55% of our communication. So watch for that. Watch what people are doing. Watch how they're sitting. Watch the rolling of the eyes. Watch the way they're turning away from people, and call them on it. You know, you're in charge of the process. This is your room. You have the right to be able to call them on the way they are acting. And oftentimes people will not realize that they're sitting there rolling their eyes. They might not. And if you are to bring it up and address it, it will stop them from acting childish in that manner. Summarizing, value silence. I think silence is extremely important. I can guarantee you that when I ask somebody a question and I get silence, I do not ever break that silence. I wait for them to break it. And the reason I do is because, first of all, I know they feel a lot more uncomfortable than I do, because I do this all the time. And secondly, if they're silent, it's usually because you've asked them a really good question. If you jump in with another question, they will answer the easiest of the two questions, and you might lose a considerable amount of information in that time frame. I think I'm almost just about within my time frame. I might be a few minutes late, and I apologize for that. I'm really at a point now where I'm ready to answer any questions if anybody has any. And over to you. Thank you so much.
Thank you very much, sir, for this wonderful presentation regarding the role of mediation. Ladies and gentlemen, this is the question and answer session, and you are requested to ask if you have any doubt or query regarding this matter. If you don't have any question, then we will go for lunch break.
There's a teaser. If you ask questions,
Sir, you have already discussed all the matters related to the topic, so I don't think anyone have any confusion regarding the matter.
Wonderful. Well, thank you.
Okay, now this is the time for the lunch break, and we will again meet in the same platform after lunch with same ID and password. Your allotted time for lunch is 40 minutes. And we will again meet here in 2:20. Thank you.